The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 980. Coming to you on Monday, the 17th of August, 2020. On this program, I will speak to you on the topic, Is Your Will Up to Date? But before getting into the topic, a few preliminary comments. Firstly, and as usual, my condolences go out to all families which have suffered recent bereavements, and in particular to the family of a legal colleague, Mr. Emery Robertson, who passed away towards the end of last week. My deepest condolences to his widow, Mrs. Dr. Shirley Robertson, his daughters, Miss Samantha Robertson and Miss Sandra Robertson, and his son, Emery Winston Jr. It particularly pained me to have heard of Emery's passing. Our friendship goes back all the way to the early 1960s, when we were both students at the St. Vincent Grammar School. We got into 6B together, got to 6A together. We did the same subjects for our A-levels, which in those days was known as this Cambridge Advanced level, our senior Cambridge Advanced certificate. We graduated the same day, and soon after graduation, he went off to England to study law. In those days, the law program was 18 months, and he came back as a qualified lawyer, and it so happened that I was his first client. When he opened his law practice, I went to him to draft a document pertaining to a tenancy that I had with my landlord. Emery Robertson was a dedicated lawyer. He did his preparations thoroughly, argued his cases fiercely, and generally mastered his briefs. It was a pleasure to practice law with Mr. Emery Robertson. Indeed, his name is enshrined in the law books of the British Commonwealth by reason of that famous case he had with Mr. Grafton Isaacs, called Isaacs versus Robertson, in some law reports Robertson versus Isaacs, which went all the way to the Privy Council and re-established a very important principle of law. Emery was a dedicated father who would be sorely missed by his family. Our paths crossed later on in life when he became the first Attorney General for the new NDP government, which took office in 1984. He was also chairman of the New Democratic Party. And when he resigned as chairman of the New Democratic Party in 1986, I was the one who was appointed to replace him at the convention the party held in Beckway, at which the late Honorable Errol Barrow was the feature speaker. My deepest condolences to all of Emery's siblings and all of his other wider family members and circle of friends. The legal profession has lost a practitioner of over 50 years standing, and we would be all the poorer for it. Excuse me. On a different topic, when I did the program last week, the general elections in Trinidad and Tobago were on. But no new government has been sworn in as yet, unless it happened today, and I was not aware of it, because the election results were very close and the opposition party called for a recount in 5 constituencies. So as of Saturday, there was still some uncertainty, and let us hope that the recount would be completed. If it hasn't been completed already, let us hope it will be completed shortly, so that a government can be sworn in. Interestingly enough, I listened to a lengthy press conference hosted by the continuing Prime Minister of Trinidad and Tobago, because, as you know, even though Parliament is dissolved and elections are called, the Prime Minister remains in office until a new Prime Minister is sworn in. But the ministers are supposed to demit office on the election morning. But I'm sure I have heard of ministers, at least the Minister of Health, still carrying on his duties in Trinidad and Tobago. Further afield, in Guyana, we were heartened to hear that matters had been decided conclusively in Guyana and that the opposition had been sworn in. The opposition leader, Dr. Ali, had been sworn in as the new president of Guyana. But then late last week, we heard the news that the outgoing government had announced its intention to file election petitions to challenge the results of the poll. So that even though the government in Guyana took office 5 months too late, it would appear that there is still some lingering uncertainty in Guyana. Final preliminary remarks have to do with the presidential elections in the United States of America. I think everybody knows by now that the opposition candidate, well, the candidate for the New Democratic Party, Mr. Joe Biden, has chosen as his running mate Senator Kamala Harris. Interestingly enough, Senator Harris's parents, her father was a Jamaican, or is a Jamaican, he's still alive. Her mother was from India, now deceased. So she is of immigrant parents. She was born in California in the United States of America, although Mr. Trump and some of his allies appear to want to throw doubt on her parentage. But the point is, there is a real possibility that the new Vice President of the United States of America could turn out to be a person of partly Jamaican descent. Not the first time Jamaica has found itself in the news, because I remember Mr. Colin Powell, former Secretary of State under Mr. Bush's administration, has Jamaican roots, and other notable figures, and other Caribbean territories. The former Attorney General of the United States under President Obama had Barbadian roots. So the Caribbean has certainly been making its presence felt historically on high offices in the United States of America. The Democratic Convention starts today, and I believe tonight the speeches would begin. They're having it virtually because of the COVID situation. You cannot have crowds gathering. And that brings me to my final remark tonight, COVID. I just want to remind the people of this country that we are not yet over with COVID. COVID is not yet finished with the Caribbean. And people must not start to behave as if the what I call the pestilence has gone, so that we still have to take precautions. We still have to distance socially if it is possible, and we still have to wear our masks in places where masks would be appropriate. We still have to carry out our hygiene, our hand washing, and so on. Thank God that so far St. Vincent had been spared any COVID-related deaths as far as we know. But let us still carry on as if we are aware that the pandemic is still a potential threat to us here in St. Vincent and the Grenadines and in the Eastern Caribbean generally. All right, so much for preliminaries. We now get on to the topic for the evening. Is your will up to date? Well, naturally, if you have never made a will, then there is nothing, the question doesn't apply to you. The question is really meant to stimulate those who have made wills, particularly those who have made wills a long time ago. And I want to alert you as to some of the problems which can occur if changes have occurred in your circumstances since you have made the will and you have not amended the will, you have not brought it up to date. Now, the first change that normally occurs after a person has made a will is that of the number of their immediate dependents. In other words, let us say a man or woman in their 30s make a will. when they have X amount of children. But let us say after they have made that will out, let me speak individually, because I don't want you to think of a joint will. Let us say a man has made a will in his 30s when he had 2 children, whom he named in the will as his main beneficiaries. And then when he slips into his 40s, he has 1 or 2 more children, or 3 or 4. Now, because those children would have been born after he made his will, their names would not be in his will because they were simply not in existence when the will was made. So he has a will. 2 children are named in the will along with his spouse or somebody else. He says whatever he has must go to those 2 children, and then they are named. Then later on in life he has other children. If that man does not update his will, if he doesn't go and get his will changed, amended, to put in the names of the children he had after he had made the will originally, and he dies, the family may discover that the only children named in the will are those he had when the will was made, and that the names of his later children are not in the will at all. That could create problems. Unless in the first will it was drafted in such a way that it said, I leave my estate, so much percent to my spouse or to this or that person, and the rest of it to my children. Now, if that will says to my children without putting down the names of the children who are alive at that time, later children would then come into the will because they would be part of the definition of children. Let me repeat. If the will that he made had said, I leave so-and-so to my children, without calling their names, then that could mean children he had at the time and future children yet to be born. Because you look when he dies to see who his children were. And those who were his children at death would then be entitled to share anything which in the will was stated to have been left to his children. But if he had named the 2 children, little Freddie and little Mary, in the first will, and then he went on to have Bob and Joe and Susan and Louise, and he dies, the later children would not be entitled to the estate because only the children whose names are written down in the first will would be entitled to take what was left in the will for them. So if you had made a will years ago, and after you made the will you had other children, you should check it out and see if those other children you have or had later on in life are covered in the will, or if you have to modify the will to put in their names. Otherwise, problems could arise when you die. then the possessions you might have had in the early days when you made a will may be different from the possessions you have when you die. You see, if when you made the will, you had a small piece of land, you didn't even have a vehicle at the time, and you make a will, you might say, okay, you're leaving that piece of land for whoever you want. But as time goes by, the Lord has favored you, and you acquire other properties. Now, those new properties you acquire may not be reflected in the will, because the will might have specified the property or properties you had when the will was made. And therefore, anything you acquire later on in life may not be covered in the will, unless in the will you simply refer to your estate. You can say in a will, when I die, I want my estate to go to so and so and so and so. Well then, if you say estate in the will without specifying what you had at the time, that would cover anything you acquired later on in life. But if you didn't use an all-embracing term like my estate, and you simply say, my property situated at New Montrose, then anything you would have bought at Annesvale or Argyle after that would not be covered, because the will would refer only to the New Montrose property. And that is another reason why, if there have been changes in your circumstances since the days when you made a will, you should go and check out the situation. Let your lawyer, or a lawyer, might be the same lawyer who made the will, but let a lawyer advise you as to what is the position. Now, there is a rule of law in this country. You will find it in the Wills Act, which is chapter 495 of the 2009 revised laws. And that rule of law says a will is revoked upon marriage, subject to certain circumstances. Therefore, if you make a will and later on in life you get married, that marriage may have the effect of nullifying your will. It all depends. You see, if you made the will shortly before you got married, and when you made the will, you had expressed an intention in the will to benefit your fiancé. You all are not really married yet, but you regarded the person as your fiancé. That may save the will. But generally speaking, subject to the conditions laid down in the Act, generally speaking, if you marry, the marriage will have the effect of cancelling a will you have made long ago. Not a recent will, because you might be able to show that when you made the will, you made it in contemplation of marriage, or when you made certain dispositions in the will, you earmarked certain things as being given to certain persons, it may be possible to interpret the will as including those. But you will not know that until you go to a lawyer for advice. And therefore, in a nutshell, if you have a will you made long ago, many years ago, and your circumstances have changed since the days in which you made that will, you should go and consult a lawyer to receive advice as to whether your will is still valid, as to whether there would be any problems, like the will not expressing certain intentions you may have had. In other words, check it out. I know some people might have made a will in 1952, and they might even remember what was in the will, and they're still alive. Since then, you have had children, grandchildren, other people have come into and out of your life. You might even know where to find that will you made in 1952. So, if you have made a will in years gone by, make sure the will is still up to date, still valid, and make sure the will covers all your worldly possessions you have and the ones which you are likely still to have when you die, so that you can make proper arrangements as to who should get what. Remember, these are not the days when persons are willing to live and let live. These days, people like to fight, especially over deadlift. So it is better, as the old people say, make show better than cock show. Better you check it out and be advised as to what is the correct position with regard to any will you would have made a long time ago. But if you have made the will within the last few years, you probably need not bother to be vigilant to go and check it out. Okay? All right, well, that is all from this program of the Law and You, program number 480. Last week I made a mistake when I said program 978. I should have said program 979 last week, which makes this program 980. Okay? So, do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.